AAM and Regina, another classic 98A. Again, the evidence was admitted as having to do with the facts or alleged facts of the offences charged. Nothing to do with bad character. The whole case was about reprehensible behaviour on his part, financial control, meanness, undermining her, humiliating her, bad language, temper, threats, bullying were all part of the facts of the case. As I put there, 98A and B merely preserve two common law rules whereby such evidence was potentially admissible. B, misconduct during the investigation or prosecution. Hugely relevant for a prosecutor who must always ask himself, herself, hey, has this to do with the alleged facts of the offences charged? Because if it is, it's in 98A. I'm not serving the bad character notices. This is nothing to do with character. Of course, it might be you go down the other route of it putting the, by way of explanatory evidence, putting today's offence into some sort of context. There's probably a bit of a crossover sometimes between 98A and putting the offence into some sort of context. As a prosecutor, you might use both.
This is part of a line of authorities, isn't it, Colin? You obviously mentioned that there's a line of authorities about movable objects at the scene, but we've also had a line of authority cases such as FNC and Sakiri, for example. FNC was that the man masturbating on the tube, and his semen was then on the victim's trousers, and then Sakiri was a robbery in Wimbledon where the robber's DNA was on the door handle of the car in which he'd obviously touched in order to open the door. And I think I think this case, the reason, as you say, it's nuanced, and if you'll pardon the pun, you talk about the time frame, but the window of opportunity for this burglary was about an hour, wasn't it? And so I think what the judge was effectively saying is, and because I think they'd climbed in through the scaffolding and through the window rather than going inside, hence why, as you said, I think the cigarette butt then ended up being lent up besides the door frame, I think, of the main door going into the property from memory. I might be wrong. But, in terms of getting there, I think there was a strong inference that it was left by the burglar. One, because there was a short window of opportunity. Two, because it was against the door frame of the front door, suggesting whoever had deposited it there had got in there through the window, which is obviously an unusual thing to do unless you're burgling the property. So, as I say, all of that, I think it very much, the net closed very tightly around this person, didn't it, to say that there was a compelling inference that the person who left the DNA on the cigarette there was also the burglar. If the time frame had been broader, if it had been over 3 days, for example, or a weekend, whatever it was, but I think there are a number, I think, relatively unique facts, but as you say, it is a little bit more nuanced, and I'm sure in due course we will see some other nuanced facts on which it would be sufficient for a jury to find, or indeed a district judge or magistrates to find, a case to answer based solely on DNA evidence. And that's effectively what FNC and Sakiri say. In certain circumstances, it will be sufficient for there to be a case to answer based on DNA evidence alone.